Let's take you here now. The third accused in the murder trial of former Orlando Pirates and Bafana goalkeeper Senzo Meyiwa has asked for the Pretoria High Court to intervene in his incarceration at the Kgosi Mampuru Maximum Prison in Pretoria. Mthobisi Ncube has provided a letter in which he claims he is being incarcerated under inhumane conditions in solitary confinement at the maximum prison. Now let's get analysis. We're now joined via Zoom by Kimmona Kannigan from Kannigan Attorneys. Advocate, thank you so much for your time this afternoon. Now, a lot, of course, has transpired again in court today. Not what we expected to hear, given, the last postponement where Advocate Defo said he was going to be talking about the, just the distribution of the fact that the court case is being held in the Pretoria High Court. But he's now changed tact a little bit. Talk to us about what you think about his strategy and what transpired in court today before we even speak about accused number 3.
Thank you very much for the platform this afternoon. Good afternoon to you and the viewers. Just a point of correction, not an advocate, an attorney in private practice. I think, I followed the trial somewhat fleetingly, but I have to say that the tactics, procedural and otherwise, that's been employed by the defense counsel has it's made for, I don't want to use the word entertaining viewing, but it definitely is the gift that keeps on giving. So definitely a little bit surprised and taken aback by the outcome of today, especially seeing that heads of argument were due on the issue pertaining to jurisdiction. And the judge definitely belabored the point that those heads of argument were not in fact filed on time. And it was a bit of a disconnect between the adjournment from the previous time and what transpired in court today.
And of course, Advocate, Defo applying to the National Director of Public Prosecutions to drop or stay these proceedings, arguing that accused number 1 and 2 were forced to confess. Is this reasonable ground for an application of stay of prosecution? And of course, as we've seen now, accused number 3 saying that he is being ill-treated in prison.
I think the important thing, as a primary starting point, it's important to bear in mind that in all civil matters, a case needs to be proven on a balance of probability. And of course, in criminal proceedings, a matter needs to be proven beyond all reasonable doubt. So at this point in time, regarding to your question, staying the prosecution is definitely a remedy available to the defense. And of course, the admissibility of confessions and admissions are often placed in dispute. So in order to establish the veracity of an admission or a confession, we would need to deal with the matter on the basis of a trial within a trial. And the outcome of that will then determine whether or not the confession or admission is in fact admissible. Of course, it's also important to remember that the right to a fair trial is a constitutionally entrenched right. And as such, when we are weighing up the possibility of staying the prosecution, that must also be taken into account insofar as will effect be given to the accused's right to a fair trial as entrenched in the Constitution. So a lot to be factored in, but definitely grounds of it's something that the defense counsel can definitely avail themselves to.
So in other words, and just for the benefit of our viewers, this application then by Advocate Defo to the NDPP is common practice, because the questions have been raised, if it is indeed common practice, given that, the trial is currently underway already.
I respectfully wouldn't, whilst it's something that the defense may avail themselves to, I wouldn't say that it's common practice. And I think it's important for us to look at the trial in its entirety and to look at the tactics that have been, and the tactics and the strategy rather, that has been employed by the defense counsel. So in saying that and having regard to the matter in its entirety, I think this really is a case that has been plagued by delays, postponements, and procedural mishaps. So having regard to the strategy that has been applied thus far, I would say that it's the defense counsel possibly trying to throw anything and everything that they can out of the rule book. It's a procedural technicality, and whilst it's an avenue that the defense may avail themselves to, I can't say that it's common practice.
I'm glad you mentioned, the delays in this trial, and just going back to earlier proceedings. One of the things that, of course, has also been raised is, this constant engagement with the National Director of Public Prosecutions. You'll recall that, the trial, as you've rightfully said, has been marred by repeated, delays related again to the second docket, where Advocate Zandile Mshololo, raised concerns, about the second docket, despite the NDPP saying the indictment, from its Gauteng division in Johannesburg, calling for the arrest of Khumalo and others, was crafted by a junior prosecutor, if you'll recall, and that the office had not taken a decision on it. What bearing does this have, in questioning the NDPP docket? What bearing does this have then on the case?
At this stage, I would be reluctant to provide an analysis on that. What I would say, though, because I haven't followed that aspect of the case as closely as I would have liked to provide an accurate analysis, but what I would like to say is that there are various inconsistencies. And as I opened with earlier on, being as it is that the burden of proof is beyond all reasonable doubt, it is the job of the defense counsel to throw as much doubt and to display as much inconsistency in paperwork, in dockets, in indictments, and so on. So I would be reluctant to provide full analysis in that aspect of the case, but I would like to say that the inconsistency obviously is the angle and the strategy that they're trying to employ.
And just talk us through, if you have been listening indeed to just some of the, testimony that accused number 3 has been saying, just basically given testimony around police brutality in prison, and what bearing this has on Advocate Defoe's, application today. Again, I haven't followed accused number 3's. I haven't followed any of the evidence being laid on that, if any. But I suppose it's something to be factored in. As I initially alluded to, if the Constitution provides the right to a fair trial, then justifiably and understandably, the accused, there are other rights, fundamental human rights, that accrue to the accused as well. So leading with or allegations of police brutality are things that would have to be presided over by the judge and factored in. But again, I would be reluctant to commit without having had full exposure to the statement by accused number 3. Just as a final question and closure, we know that, of course, this trial has been set back to resume in September. How likely is it that, it will pick up where it left off, given, the delays, the constant delays that we've seen previously?
Wow, that's a loaded question. What I will say in response to that is, when I in my research and prep for the interview, I was actually a little bit taken aback when I realized that this was actually a 2014 incident, and we're now in 2022, so it's several years down the line, and I can't help but draw a comparison between this and the Oscar Pistorius matter, where the matter ran like clockwork procedurally, and in this instance, like I've alluded to earlier on, with the matters being plagued by delays, postponements, and adjournments. So I would be pleasantly surprised if the matter ran in September, as it's been adjourned to, but I suppose in the interest of justice, we're all hoping for the best.